Okay, Disability Rights Florida is your state's protection and advocacy agency. We are free, legal, and confidential legal services for persons with disabilities in the state of Florida. Every state is mandated to have a protection and advocacy agency, and Disability Rights Florida is our state's protection and advocacy agency. We represent from children to adults, and there is no income requirement. Today we're going to cover special education law for students with disabilities from obviously the perspective of an advocacy agency that works on behalf of children. So we're going to cover the, soup to nuts process, and I'll try not to take too long. This is like 6 hours of content crammed into an hour presentation, but we're going to go through the initial evaluations, eligibility, IEP. We have some 504 information in there, procedural safeguards, dispute resolution. My favorite subject is discipline, behavior, transition, and resources, and then our contact information if you have a need for our services. It usually starts out with the child being referred to, whether it's a teacher referring or a parent referring, but saying that they suspect that the student has a disability. And the school districts have a child find obligation to identify students under a disability. So normally what takes place for our children is the parent has come to us and said that they've requested an evaluation, and it kind of gets the ball rolling that way. So evaluations are used for assessments. They must be measurable and valid and reliable, administered by a trained and knowledgeable personnel in accordance with the instructions provided by the procedure for assessments. And all that means is we need a school psychologist who's going to be looking at the student for, academic functioning, intellectual functioning, those kind of areas. Normally, if there's speech or language concerns, you'll have a speech-language pathologist involved. If the student has any fine motor, occupational therapist could be involved, physical therapist, but a screening by a teacher is not considered an evaluation for evaluation purposes. So a child with a disability is a student suspected with a disability under the Individuals with Disabilities Education Act, and it has, it's not as broad as Section 504, but it looks for whether a student has an intellectual disability or hearing impairment, speech language, visual impairment, whether the student may have autism, traumatic brain injury, specific learning disability. And the key part to that is they may have a disability, but they also need to have special education and related services. So just merely having a disability alone is not enough to meet the normal eligibility criteria. So oftentimes when we have a student and we contact the school district and we say that there's an issue and we'd like them to evaluate the student, they'll come back and tell us that they need to do some interventions and they have a process to go through before they kick into doing the evaluation process. But those general ed interventions are not required if the student has a speech disorder or a severe cognitive impairment, physical or sensory disorders, severe social behavioral, or for preschool students. They are required for other students in suspected areas of disability, but the evaluation can be done concurrently with those interventions. So there is no such thing as we have to do these interventions first before we can do the evaluation. They can do them at the same time. And oftentimes the interventions will suffice and the student won't need to go on to be further evaluated. But the majority of the cases that we see, the student ends up being evaluated, and probably a larger percentage of our students do meet the criteria and end up being or an IEP written or a Section 504 plan. So in order to conduct the initial evaluation, they need to get parental consent for that evaluation. So it must be obviously knowingly done and explained to the parent. And just because a parent consents to the evaluation does not normally mean that they're also consenting for the special education services. It's a two-step process. So just by asking for the evaluation doesn't necessarily mean that you've already agreed that the student will be, an exceptional student education student in the state. And the school district must make reasonable efforts. There are times where it's been the flip side, where it's not the parent, but it's the school that identifies the student and has suspects that there's a disability, and the parent doesn't consent. So they must make reasonable efforts to consent. And of course, if the parent refuses, the parent then can in turn come back and tell the school that you've denied, to provide my student specially designed instruction because the parent has not allowed the school district to move forward. We don't normally see those types of cases, but we've had a few where the parent's concerned about the eligibility label, and they don't want their child to be saddled with having this disability. And we often explain to the families that this is the means to getting the services. If your child truly has a disability, then they need to have this eligibility in order to get the specially designed instruction and related services. So 60 school days. So upon receipt of the parent signing consent, they give it to the school district. This normally, in most districts that we deal with, takes place at a formal meeting where the parent signs consent and they discuss what areas they would like the student evaluated in. There is no requirement that it take place at a formalized meeting, but it is helpful because then we know what they're asking, what we're looking for, and how to move forward with that. But with time that the school district receives that evaluation consent, they have 60 school attendance days in order to complete that evaluation. And for pre-K students, it's 60 days after the receipt of the parental consent. Yes?
For our purposes, parent, would that be the caregiver if the child's now home care?
What do you mean by caregiver?
Foster parent, relative, caregiver, non-relative, whoever the child is placed with through DCF if the child's now home.
Yes, who meets the definition of parent under IDEA, and that would fall.
Or educational surrogate.
Yes, definitely an educational surrogate, which I'm glad you bring that up because we go into that further into the evaluation process. Yes.
Does every school district have their own rules? Because it seems as though I'm an educational surrogate parent, and some school districts that I deal with don't seem to care to have needs signed, and some feel like I must sign for consent.
Well, if you're the ed surrogate for that child, then you need to sign consent. IDEA is very specific, and I'm jumping ahead, but it's very specific that and whatever term the community-based agency is using, whether it's caseworker or child advocate, they are not the parent for special education services. So yes, there are some cases where the foster parent would be considered the parent, if the student has the parental rights terminated and an ed surrogate has been appointed, they sign for those purposes. So it's really very important that foster parents, caregivers understand the ramifications of what they're asking for and doing and understand the process. Because as you'll see as we go along, there's some very critical decisions that have to be made educationally that will affect these children for the rest of their lives. So I'm a strong proponent of making sure that everyone has fully informed consent and knows what they're doing in this process. Because the first thing that I learned when I was trying to navigate is that it's pretty clear as mud. You know, what I think the rules are saying is not necessarily what the school district may think the rules are saying, and things are not really clearly defined in special education law. We use a lot of terms like reasonable. Well, I know what reasonable is for me, because I want it yesterday. So I think, you know, reasonable is going to be a much shorter time frame, but there's no like hard and fast, well, reasonable, you know, henceforth means that it will be 60 days or something. So there's a lot of gray area and a lot of, you know, differences in the circuits and things like that. So it's really important for, you know, parents, caregivers, legal guardians, surrogates to be educated in this area, to know what the decision-making process is and know the ramifications of their disability. So another issue that we see a lot with eligibility is there's kind of this battle of, well, part of the IEP team is saying that the student qualifies under this specific eligibility. Like for instance, we had an issue recently where the school district thought, and I mean school district, I mean the school staff members on the IEP team were thinking that the student had an emotional behavioral disability. But the parent clearly thought that the student did not, and it was due to other health impaired and the child's ADHD. And there was kind of this battle going on. And one of the things that we've always said is it's not really the eligibility term, because needs are what drive the services. It's not what the child is, you know, quote, eligible under. So say the student comes under autism. So there's no hard and fast, all children with autism get X. It has to be based on that child's unique needs. And sometimes you'll have a student with a disability and still it kind of gets caught up in that whole conversation. Well, wait a minute, a child with a specific learning disability wouldn't have that behavioral component to their disability. There's no such thing. It's based on that child's unique needs. So the way to look at it, and the way it had been told to me years and years ago when I was learning, is it's the key to the door that gets you into exceptional student ed. All services should be based on that child's unique needs and not based on a label. So when they're looking at eligibility, there are certain criteria to fall under the different disabilities, but there's no such like one test, you know, will do it all, and they'll go through what, you know, the state board rules say, and they'll look at all the different input, the school psychologist, the speech therapist, the classroom teacher. That information is vitally important because the school teacher sees that student for the large part of the day. The problem that we've seen as advocates is when that teacher is not familiar with that disability and what the manifestations of that disability are, and oftentimes we'll have that almost, I don't think he has that, I think he willingly or wantonly chooses to do, those are my trigger words, he chooses to not. And when it turns out the student may have a processing disorder. So it's not a matter of defiance, it's a matter that the child is not processing the language that's being, you know, shared in the classroom, and so it's not just an outward defiant child, but it is a child under disability. So one of the things that concerns me as an advocate is making sure that the people on the committee are understanding and educated in what that disability looks like. Because honestly, as you know, is being around no two children are alike, so why would every child with a particular disability present the same way? So 504 eligibility is much broader than IDEA. It's a person with a physical or mental impairment that substantially limits one or more major life activities. And that activity does not have to be learning. There are students sometimes where socially they'll have anxiety issues. That's impeding their social interaction with their peers and with other members of the faculty and staff. And so it is impeding them, or the student has inability, physical impairment that makes it difficult for them to access the school campus. They may be an A student in the classroom, but they may need some accommodations based on their physical impairment. And I think a lot of times the struggle that we see as advocates is when we get bogged down in, but the student's making A's and B's, or the student's gaining educational benefit. Well, I'm not saying they're not, but I'm saying there is an impediment to their access to learning, and it's not just grades. So I know that a lot of times we spend a lot of battles in our meetings fighting over whether the student is really a student with a disability because they're making good grades. And grades, in my opinion, are sometimes very subjective. I've seen work that I would think, wow, this student's doing really well, and you look at it and the grades are not that great, and then there's other work where the grades are not reflective of the actual work that child's putting out. It's almost like, I think, the teacher feels like they're doing it, they're being mean or a disservice to the child, so they're a little more lenient in the grading because they know Johnny works so hard. But that's not helping Johnny. If Johnny needs that extra service, getting a grade isn't going to help. They have to earn that grade. Yes?
Is suffering trauma considered a disability under the definition?
It depends how the trauma is manifesting. Are you just, we have some students who've had significant abuse in their past, and they would qualify under emotional behavioral disability. So it's like the standard lawyer answer. It depends. So. Okay, so a student who is eligible for Exceptional Student Ed, which is a student that's covered under the Individuals with Disabilities Education Act, is also protected under Section 504 of the Rehabilitation Act, but it does not work in the reverse. So just because a student's eligible for 504 plan, that's an accommodation plan and services, does not necessarily mean they would be qualified for Exceptional Student Education services. So it has to rise to the level of needing that specially designed instruction. Which I hear that in my sleep because we have a lot. So IDEA is very specific about the categories that they have for disability, where 504 is very broad. And the student's educational performance must be adversely affected. We would say 504 does not require that strict an adherence to that. IDEA, the student would need specially designed instruction, where under 504 it's a substantial limitation of one or more life activities. IDEA covers you from our students from, we say, birth through the 21st year, where under 504 there's no age limitation. So the individual education plan is what a student gets when they've been found eligible under IDEA. And I know we have a lot of acronyms in our. So if the student's going to get an individual education plan, it must be updated at a minimum of once a year. And it can be updated more frequently if necessary. And these are the important sections. I think they're all important. So it was kind of hard. I'm sitting there writing what are the important sections, and I basically listed every section under the IEP. So when you come to the meeting, they normally do their introductions. As a parent, you'll be told, you'll be given a copy of the procedural safeguards, and then they'll ask if you want an explanation. If you don't understand, please ask for that explanation. Like I said, to me, starting out, it was clear as mud. So there's no silly questions, and there's no need to pretend you know something that is clear as mud. Ask for those. They'll start off the IEP with drafting your present level of performance. That is so important because that's what's going to drive the services and the goals that child receives. I've got to tell you, I've got a lot of parents who tell me all the time, oh, I don't like to put the bad stuff in. Well, but that's where we know where we need to write those goals and where the weaknesses are. It's great, you have to have the strengths in there because we're going to play off those strengths. But we really need to know what that child needs in order to write this plan. So that present level is really going to drive the rest of your child's individual education plan. So after you're done writing that, and most parents are depressed after that, we go into the goals. And the goals are really the services that the child is going to do. They need to be measurable and they need to be realistic. So I'm kind of jumping ahead because I'm used to getting carried away with talking and not so much looking at my own slides. But the present level performance will be the effect of the disability and your priority educational need. And as I said, that is going to drive your annual goals. The annual goals must be measurable and they must be intended to move the student forward. My pet peeve is to see an IEP that is going to leave my client continually behind the 8 ball. So we're looking at a minimum of a year's growth, a year for a year, and I think that's often reasonable. But what I really gets me going is when I see an IEP where a child is 2 to 3 to 4 or more years behind, and we're writing a goal that they'll make a half a year's gain because we don't want to frustrate Joey. Well, how frustrating will it be when Joey's in that classroom again and again while everybody else is moving on because he's eking along at a half a year's progress? Now, I know there's going to be some exceptions to the rule, and there's going to be some children where that half a year growth, because it's based on individual needs, may be appropriate. But if I have a client who is in the 5th grade and they're still reading on a 1st grade level, I want to know what specially designed instruction will be provided to close that gap and get my client reading as close to grade level as possible. So sometimes a year for a year is not enough. Sometimes we want to look for more than that because we want to close that gap. Because the whole purpose of special education is to educate students with disabilities. I can tell you that there's nothing more frustrating than sitting at a meeting and hearing, well, you have to understand, Ms. Siegel, he has a disability. Well, of course he does, or else we would not be here. But just because he has a disability doesn't mean he can't learn. It just means he learns at a different way or pace than the child sitting next to him. But what we really need to emphasize is that special education needs to be special. It can't be a one-size-fits-all, because I'm sure you'll agree, we don't all wear the same clothing size. So we don't all learn the same way. So that education needs to be specifically designed to meet that child's unique needs. And I gotta tell you, that's gotta be daunting for a teacher who has 15 kids in the class and several students with individual education plans trying to meet each one of those children's unique needs. But that's what the law says, and that's why we have an individual education plan. So we have short-term objectives, and short-term objectives are not necessarily required for all annual goals. If you have a student who is on Gen Ed standards, when IDEA was reauthorized in 2004, they took away the requirement to have those short-term objectives. I see a lot of school districts still using them, and I think that's great because those are the baby steps that are going to get us to that annual goal. So I'd like to see them, and I think they're important because they help us foresee how we're going to get to that year gain in what increments. Related services. Related services are, those services where the child requires so that they can benefit from special education. Oftentimes we see speech therapy, occupational therapy, we have a whole list. It could be counseling. And again, remember, related services need to be based on the child's needs. We We shouldn't hear things like, oh, I'm sorry, but Johnny has ADHD. We don't give that service to children with ADHD. It should be, if Johnny needs that service to benefit from special education, then that's what Johnny should be getting. Assistive technology. There is so many great programs, software, devices. In January in Orlando, they had the ATIA conference. It's amazing the different devices that are out there and how innovative some of the school districts are in working with students with disabilities and getting communication. Yes?
Can we go back to the, can we go back to the related services?
Sure. What do you need?
Especially with speech and language therapy, what I'm finding is that the children don't qualify for services in the school based on the evaluations and assessments that are given, yet oftentimes they have, especially in language processing, receptive or expressive, and they're not qualifying in the school. They have to go out privately. So how can you change the test so they can get the services in the school?
It's funny because we constantly hear the medical versus the educationally relevant test.
Right.
So it may be medically relevant, and a lot of parents think like getting a prescription from their pediatrician is going to give that child that service, and it doesn't, because there's eligibility requirements to be eligible for like speech. But speech can also be given not as an eligibility, but as a related service. So we just had a case a couple of weeks ago where I was sitting there thinking there's a significant issue. And when they did the steps that they go through to see whether the child has a speech impairment or language impairment, because those are the two things that usually trip me up, where speech is more of an articulation and language is more of a communication pragmatics kind of thing. The child did not make the, quote, eligibility for the language services, but they gave them to them as a related services because it did impede their educational learning. It just did not rise to the level of being an eligibility in and of itself.
Okay.
Suppose the service, of course, the school's providing the service, but it's providing in a very limited fashion or in an unproductive fashion. One therapist for 10 students at one time, or 1 hour a week when the parents or other people feel that maybe they should need more.
The most frustrating thing that I have to deal with in special education is there's no maximizing of a child's potential. And there's something out there where they say, well, more than de minimis is, as long as they're gaining some educational benefit. And I've had certain administrative law judges who think some educational benefit is a lot less than what we think is some educational benefit. But it needs to meet the child's unique needs. And one of the things that I know, and I'm not saying your question hits this, but it brings me to another thought, is sometimes parents think that one-on-one is the key. Johnny had that speech one-on-one, but it's good to have a small group because they have other students and the exchanges and someone to model off and work. But if they're so large that child's not getting the educational benefit, it's not appropriate, and we would go back in and ask for them to revisit the service delivery model because we don't feel that the child's making meaningful progress. And the school's responsible for keeping data on how that child's achieving their goals. So if you look at the data and it shows that the child's not making any progress, then Houston, we have a problem, and we need to go back to the IEP team and we need to discuss how we're going to address that to meet that child's needs, because it's not working. Like I said, one size doesn't fit all, and sometimes you will hear things because people are kind of set in their ways. Well, this is how we deliver it at that school. But that's not how IDEA says we deliver. We deliver it to meet the unique needs of the child. Realistically, I know that, and I've been told my clients are not going to get Cadillacs, but they're going to get a Chevy, but the Chevy needs to have wheels and it can't be up on blocks. It's got to run. So what we want to say is wherever you have a child that you're representing and they're not making meaningful educational benefit, ask for the data that's being kept. Let's see why. Maybe it's the program they're using. We have children that are forever put in the principal-chosen reading program for the school. And this kid has been in this reading program, which is the definition of insanity. You're doing the same thing year after year, expecting a different result, and nothing's changing, and nothing's moving forward. And meanwhile, we're saying, well, he's not motivated. Well, of course he's not motivated. He's not been successful. So you need to look at whether the programming is meeting your child's unique needs, and what is the data showing? Because every decision that's made is supposed to be made on the data. What is it showing us? Is this effective? Is this working? I mean, if you wouldn't go to your doctor and take the same medication year after year if it wasn't helping, you know, what your illness was. So we shouldn't be doing it in special education. So if it's too large a presentation that it's not assisting your child, then the IEP team needs to reconvene and look at what the data is showing and how we can change that in order to meet that child's needs. And that's like assistive technology. There's a lot of great devices out there, and I'm probably one of the least savvy on AT devices, but there are a lot of devices out there that can help our children communicate and help them with social skills. I mean, there's a whole host of things, and I also am cognizant that the school districts do not have endless resources. And sometimes I'll go into counties, because we have 67 of them, and they may not know what's available. So it's not a matter of malicious intent of hiding it or trying to save $1. They didn't know it was a resource out there. In some of our smaller rural districts, they don't have the resources that some of the larger districts do. So, you know, we're a member of the team, or the parent's a member of the team, and we help educate them. But there's so many different devices out there that can help our children be included in the gen ed, to communicate to their peers. And so it's important that AT be looked at. And we'll have like a list of my pet peeves, but my pet peeve is when we go in an IEP and they just zoom by assistive technology because the sentence was, oh, Johnny didn't have it last year, so he doesn't need it this year. Well, how do we know? We should look at AT. And if the IEP team decides to look at assistive technology, then the assessment must be completed within 60 school days after the team's recommendation. And some places do it really good, and they go in there and they look, and there's some really great assessment tools out there to be utilized, and some not so great. So, you know, it's really important to look at, you know, my goodness, at ATIA there was this wonderful presentation from a school district where one of their concerns is iPad. iPads are great. They've got a ton of apps. Apple is wonderful. But they were concerned that the iPad would be a projectile and that their students would flip it across the room. So what they did is they got these really great OtterBox cases, which you could probably throw it across the room and they survived. And they made their own mounting devices out of PVC. This one teacher was so innovative. He had these great blueprint designs on how the devices could be locked onto the table so the child would be able to utilize the device and get benefit from it. But they didn't have to worry that if Joey got frustrated, it would go flying across the room. So there are, you know, great ways, and when we really want to be innovative, we can. It's just a matter of getting people out of their comfort zone and having them look outside the box. So it was really amazing, and the things they were doing with the students, and this whole presentation was on students with significant cognitive impairment and the educational benefit they were gaining from those AT devices. So I'm going to go on to accommodations and modifications because that's one of the things we find that gets bantered about but often misused. So we'll ask a parent, is the child receiving any accommodations in the classroom? Oh no, they're modifying the class. Are they really? So the definition is accommodations are adjustments to the curriculum that don't interfere with the standards. So they are truly receiving gen ed standards. A modification is something that will substantially change the standards. So it may not meet the Sunshine State standards. It may meet, they may be modifying the curriculum so far beyond recognition that it's not really the true gen ed curriculum, and then that child is not really on gen ed standards. And sometimes we'll have parents that will ask for their child to be included in a classroom because they want them to be in the least restrictive environment and with their non-disabled peers, but the problem is they want the curriculum modified so much that it materially alters the program. And that's where we have to tell them that that's not the way the least restrictive environment works. So it's the maximum extent appropriate, it's like a tongue twister. The maximum extent appropriate children with disabilities should be educated with their non-disabled peers. So that's, again, an individual issue. It's based on that child's unique needs and what that student needs. So we're not going to advocate for inclusion for the sake of inclusion. The child needs to be gaining educational benefit. And that's important because sometimes we'll get bogged down and but they're not with their non-disabled peers because the way the curriculum has to be designed for that child, their non-disabled peers would be learning at a much higher rate. But our goal, personally, at our agency is to try to get students as included as much as possible and appropriate for those children to be with their non-disabled peers because this is the world they live in. They are not going to be going to a special ed Walmart. We want to prepare our children to be as independent as they can be post-secondary. So putting them in these artificial kind of programs, which are great if you're going to really remediate those areas of need and work on those the low reading or the low math skills, that's really important. But learning to live in our world and function in our society is also vitally important because we need to start preparing our children to be meaningful participants. And that's in this world because there won't be a special ed world. 504 plans are not as formal as IEPs. They are written plans. They usually have some accommodations listed. They can have related services under 504, but there's not the requirements as of IDEA where they must be addressed every year. And so they're a lot less formal. Reasonable accommodations, here's what I love, reasonable, there's that term. Reasonable should level the playing field. It does not provide an unfair advantage, and I could retire if I got a dime for every time I heard, but that's not fair to the other children. That's not what a reasonable accommodation is. A reasonable accommodation is to level it. It's so our children are on the same field as their non-disabled peers. So it's not an unfair advantage. And I have to admit, I'm hearing that less and less. But when I first started advocating, I would hear that all. Well,
That should say not.
oh,
They do not provide the student with
yes, they do not provide. That's my typo. Thank you. They do provide. No, they don't. Thank you. There you win. You found it. I'm sure there'll be a few more typos in there. Yeah, no, they do not provide. I'll have to write a goal for myself later. I already have a behavior intervention plan. So. Procedural safeguards. The right to participate in all meetings, the right to examine. Not this last legislative session, but the session before, we had a Senate Bill 1108. And with that, it gave parents the right to bring whomever they deemed appropriate to any meeting. That could be your 504 meeting, it could be your IEP meeting, it could be your teacher conference. It's important because it gave parents a right they already had statutorily, but I think it emphasized that. And it gave parents who were in certain areas of the state who were being discouraged or felt being retaliated against the right to bring an advocate with them, or their best friend, or, you know, their grandmother or their sister. It's important, I think, for parents to have that ability to bring somebody else with them, because as caregivers and parents, it's an emotional process for us. So we're going to let our emotions sometimes get in the way. Having that other person there to help keep us on track and to advocate when we might not be in a position to is important. So parents have the right to written refusal. So if you're in an IEP meeting and you ask to have your child's speech in a smaller group, and the committee comes back and says, well, the data doesn't support that, we're refusing to make that change, they need to put that change in writing to you, and they need to explain why. Another pet peeve of mine is when we're at a meeting and they say, we're not going to do that because that's not the way we do it here. And then about 10 days later, I get something from their legal department that says, after careful review of the data, it does not support that change that you were requesting, therefore we are denying it based on teacher observation, teacher records, you know, and it goes through this whole host of legally defensible reasons, but that's not what was discussed at the meeting. They said no because they said that's not the way they do it. But, you know, that's just one of the things that we as advocates kind of hear, and there's no right to have that written refusal right at that meeting. But they do need to give you a refusal, and then you have the right to do in your procedural safeguards how you want to dispute that. Sometimes you can do an informal resolution. Sometimes you can go to mediation. Sometimes a state complaint is appropriate. And other times you may file for a due process hearing. So if you file for due process within 15 days of receipt of the filing for due process, the school district and you will participate in a resolution session unless both parties don't feel that's necessary and they want to move right on to hearing. But the good thing about mediation is I find mediations are more of a win-win situation, because you sit down there with an unbiased party and you all work together to try to come to a resolution. And if you do, that resolution is legally binding. And it also doesn't take the time that a hearing does or the expense. And it's not only monetarily expensive, it's emotionally expensive. So I am a big proponent in mediation. Surrogate parents. So a child who's awarded the state may be appointed a surrogate parent by a judge overseeing the child's case, or in some school districts that are really on top of their game, they identify that the child needs a surrogate and they appoint a surrogate. I have been a surrogate parent both through the school district appointing me or having a judge court order me to be the surrogate parent for a child. A surrogate parent cannot be an employee of the school district or or the child's caseworker or community-based agency provider. But I'm here to push my little plug for guardian ad litems to be an ed surrogate, because I think they are the greatest resource, because they're so involved in the child's life and they know the day-to-day that it's really great when they become ed surrogates. And I've worked with several amazing guardian ad litems as ed surrogates. Dispute resolution. We always try to resolve it at the school level. It's best for the child. When you're in a meeting and it's getting contentious and your child's 5 and there's a whole possible up till 21 working with the school district, we don't really want to go in guns a-blazing. You kind of want to walk in and try to work with them. Sometimes you have to go up what I call the food chain and contact the principal or the district people, or you can request a facilitated IEP. Those have been working really well for us. They have a facilitator come in and help keep the IEP team on point and listening about what the child needs and not about the personality conflicts. And there is also conflict resolution, mediation, state complaints, and all that. The procedural safeguards for 504, parents have a right to receive the notification of their child identification, evaluation, placement, review their child's records. Yes.
Can I just go back a second? A facilitated IEP meeting, who's the facilitator normally? Is that someone from the school board, or is there like a party? So probably not.
Depends. Some school districts have participated in the training with Department of Ed. They did a really great training last year where they trained the district staff or whoever the school district chose to be facilitators to come in and do that. And we've also participated in some where they brought in an outside facilitator. So it really depends on the school district, but it was the few that I participated in have been very successful. Because when we start to get at loggerheads and we're human, the personalities start to come out, it was really great to have that facilitator to go back and say, wait a minute, let's look at what the data says, and let's, and kind of bring us back to getting that. So it really depends on the district, and we have gotten them from DOE, but I don't know how often that happens. I haven't had them every time. Sometimes I've had school district people who were trained to be facilitators. Yes.
I'm sorry, can I go back to surrogate parent for a minute?
Sure.
Many of our guardians go to the IEP meetings and the 504 meetings, but they haven't had that official designation by the court. Is it advantageous for us to get that from the court? Does it bump them up?
Well, yes, it gives you the rights of a parent. So as the guardian ad litem sitting in the IEP meeting, you're a member of the team and you have, that. But when you're in the parent's position, now you have the right to consent or not to consent to those. And as a guardian ad litem, you probably know the child better than most, because one of the things that I found in my experience was the guardian ad litems tend to remain, where foster parents may change monthly. I mean, that might be an exaggeration, but I had one child that I used to advocate for who was always scared at the end of the day because he didn't know if his foster parent was coming to get him or if they were going to show up with his bags to move him to a new placement. So the one constant sometimes is that guardian ad litem. So I think it's really great if they can do that. Okay, 504 grievances. It kind of steps you through the process there. I'm not going to really spend too much time. I've kind of laid it out in, what you need to do. Contact the 504 coordinator at the school. You can do a 504 grievance with the school. You can file with the Office of Civil Rights. The Office of Civil Rights does not always take every case that is filed with them. So it depends on whether they deem that it's within their jurisdiction. But there are your grievance procedures under 504. Discipline. This is kind of what's been known to be the 10 fake free days. A child with a disability can be suspended. We get a lot of phone calls about, they suspended my son and they can't do that because he has a disability. A child with a disability can be suspended. After the 10th day of suspension, and it doesn't all have to be consecutive, it can be cumulative. And after that 10th day, the procedural safeguards for that child kick in, and we need to define whether it was a manifestation of that child's disability. So if it's not a manifestation, the child can receive the same consequences as their non-disabled peer, with the exception of they cannot be denied a free and appropriate public education. Now there's the serious 45 days suspension, where oftentimes our children are removed to a different setting, and that's because it's kind of like the zero tolerance issues of weapons, drugs, or infliction of serious bodily injury. There is a definition for serious bodily injury. It's more than just the child had my shirt in a death grip. Okay, that doesn't quite meet the definition, although I've had some people think it does. But if it does, if the child unfortunately does brings a weapon and has illegal drugs, they can be removed for 45 days, but the determination of that placement should be done by the IEP team, and in many districts, I have administration determining where the child should go, and it should really be the IEP team. If the student is going to be suspended over those 10 days, we need to have a manifestation determination. And there are two key questions. If the conduct in question was caused by or had a direct and substantial relationship to the student's disability, or if the conduct in question is a direct result of the LEA's failure to implement the IEP. I go to a lot of districts, like I said, I've heard 10, 15 different questions that they go through this whole process. But those are the two questions that IDEA specifies. If it is a manifestation of the child's disability, they do not receive a consequence. You may want to change the IEP, you may be asking for a functional behavior assessment and a behavior intervention plan, but the child should not receive a punishment for a behavior that was part of their disability that they could not help. So we would not penalize a child for not being able to read off the blackboard if they were visually impaired. It's the same thing. If the student could not help it, but that doesn't mean we shouldn't address it in a goal, and we shouldn't address it in a behavior intervention plan to move forward to make sure it doesn't happen again, and what services should be afforded that child. So when we do that, we look at a functional behavior assessment to make sure that, you know, what was that trigger? What caused that behavior? And then positive behavior intervention plans. They're positive. They're not punitive. I say that because I see that a lot. I see a lot of consequences in there. What we need in a positive behavior intervention plan is a way that the student is going to benefit and learn from that problem so they don't repeat that offense. So it has to be something the child's going to buy into. Sometimes I see, if Johnny's going to be good, he'll get stickers. Well, that's great if stickers are reinforcing, but not many high school guys want stickers. So it's got to meet what that, you know, it's going to work for that child. Maybe video time, computer time, you know, but it's got to be something that's going to be reinforcing to the child, because this is a behavior that's been picked up. And I got to tell you, it's going to take a lot longer to decrease than it was to gain. So I always tell people, get in there and try to get that behavior before it becomes a routine. And oftentimes I'll hear from schools and they'll say, well, we started the behavior intervention plan and he's off the chain. He's acting worse than he ever did. Well, that happens. But it doesn't mean that, you know, it's going to get worse before it gets better. You got to keep working at it. It's a learned behavior. You're not just going to, oh, wow, we're doing something different, and the child's going to snap out of it. So we're moving into transition, and I know there's a lot of other transition, so I'm going to try to breeze through this for you all. But federal law guarantees every student with a disability the right to move from school to post-secondary. What is transition? It's a result-oriented process that's focused on improving academic and functional achievement of the child with a disability to move them to be successful into post-secondary, which is after high school activities. You know, some parents ask me, when should I start thinking about transition? And I tell them when their child's diagnosed. Because life's going to be different. They're going to learn differently. There's going to be other obstacles. So, speaking as a parent from a perspective of I have a daughter in college now, I see things a lot differently. So you really need to start planning early on where you see your child realistically being. And I am a proponent of having high expectations. I don't think you can ever have too high an expectation, because every time I have, my daughter has always risen to that occasion. And there were a lot of people when she first started out who didn't believe that she was ever going to read. And now she's a junior in a university in the state of Florida. So they were wrong. And they all thought I lived in denial. But having high expectations and her working really, really hard, because it was not a cakewalk. There's a lot of people who put a lot of time and a lot of teachers who put a lot of sweat equity into making sure. But I think it's really important to have those realistic expectations, to look at the child's present level of performance, make sure the supports and services are those that are going to help support that child into post-secondary. Looking for that constant one-to-one aid, we want to kind of fade that out, because in post-secondary, that aid's not going to exist. So we want to make sure the child has the supports and services early on, but then as we have a plan to fade that out so they can be as independent as possible. Same thing with transition plans. There's no such transition 504, but there are plans to transition. They're just not called transition 504 plans. But they are entitled to have them, and they are to be geared to helping move that student to successful post-secondary. It's going to be your plan and tell you what accommodations that child needs and what services they're going to need, and what is your desired outcome. And that is important for the children, because although they're almost adults, and we still call them children, to be a part of. What do they want to do when they grow up? I know some of us are still trying to decide that. But, what are they going to need? What kind of job coach or supports or services? And that's another important area to have high expectations, because we see a lot of kids after high school sitting on couches. And that shouldn't be our post-secondary goal, unless they're independently wealthy, and then I would like to be sitting on a couch too. But we want to make our children as independent as possible, and sometimes as parents we want to shelter and make sure that they're taken care of, but we need to keep those high expectations, get them the training they'll need so they can move forward. Thank you. Functional vocational assessments and career assessments, finding out where their strengths lie and what they need. It was funny, personal story, my daughter wants to be a photographer, but they wanted her to go through this career inventory that was going to take several days. The school district actually had a program, and they sat with her and she went through this career scope, and at the end it determined that she wanted to be a photographer. It worked. Okay, so the school is going to, IEP team is going to sit down and we're going to draft a plan and decide what services need to be provided. And that's a good time for those other agencies to get involved, whether it's APD or the Division of Vocational Rehabilitation, but get them to the table so we're all on the same page and we're working together. Transition in the state of Florida starts at 14. I say it starts earlier, but it can be, if appropriate, on the 22nd birthday. That's when, through your 21st year, where students' services usually stop their IEP and they've moved on to post-secondary. Diploma options, that's one of those vitally important decisions. The diploma you choose has lifetime ramifications. These are what I found that are available in the state of Florida. Choose carefully, because sometimes you'll hear things like, well, I don't want to take that extra year to graduate with my regular diploma. I want to graduate and walk with my friends. But if you take that special diploma option, then that's going to limit your options afterwards. We have a case we're involved in right now where they put the student on a special diploma and she cannot go to college. She did not understand that when that special diploma option was offered. A lot of people think special diploma is a diploma that students get when they're in special ed. That's not what it means. It's not a general ed diploma. It will limit the options that that child will have post-secondary. Some vocational schools, colleges, military recruiters won't accept special diplomas. So it's important when you're making that decision to know where you're going to see that child, and I don't think it's a decision that should be made before high school, but sometimes we get clients who are in elementary school and they're already on a special diploma, and we've limited that option. That child will have to get a GED in order to go in, and I gotta think that's gonna be awfully hard if you've not been exposed to those gen ed standards. All of a sudden, take a general equivalency diploma and get it. I think it's like learning your whole life in English and taking your final exam in Japanese. Just to me, I don't think it's possible. So when they get to post-secondary, those meetings are not as formal. I know the meetings that we go to at college with my daughter, she goes now by herself. She's put me out of a job, and she meets with the Office of Students with Disabilities, and they develop her plan and the accommodations and what assistive technology she's going to be using. And there's, it's a lot less formalized. You have to ask for accommodations in order to get them. Like if you don't speak up, the Lord can't hear you. So you've got to ask for those accommodations, and they're not going to be as specific as your IEP was. You're not going to have these goals. You're just going to have what the student needs to be successful post-secondary. And one of the things we tell families, you need to have an updated psychological, usually for the Office of Students with Disabilities. They'll want to look at the student's former IEP. And when you start thinking post-secondary, you start looking at what the requirements are for post-secondary, so they know. Child turns 18, rights transfer. That's when all parents cringe, because now they're in the driver's seat and they're making the decisions. So this just speaks to agency. It's really important if your child's involved with APD or DBR to have them at the table and help them, they're all working towards the same plan. If you are, if your child is going to be involved with Division of Vocational Rehabilitation, have them do an application and have them make sure that they come to the IEP meeting if they're involved. So this way that we can kind of divvy up who's responsible for who, and the student could be involved with Division of Vocational Rehabilitation or Division of Line Services if they are eligible. Fill out an application. If you're denied, you must get a denial in writing, and you do have appeal rights. If they're not denied, they'll get an IPE. So we could have another acronym. I had to throw that in there. It's an individualized plan for employment, and that's the blueprint for what the services are going to be for that student through Division of Vocational Rehabilitation. There's some resources for special education. And if you all need our services, as I said, we are free, confidential legal services. This is our contact information. First line is our first team. They will do an intake, and then you'll be assigned to a specific team. Yes?
With regard to the IEP and our kids moving from school to school, I've had different answers to this question. Does the IEP go with the child, or does the new school then form their own IEP?
The IEP is the child's plan. It should follow the child school to school.
How do you deal with them when you get a child into a new school saying, that's from that school, we want to do our own IEP?
Well, then they got to do their own assessments. because they're supposed to provide comparable services to that child. And, you know, that IEP team, oftentimes if you move to another school, they haven't even had the time to know your child. So how can they properly draft a new IEP for that child?
And then are they obligated to be interim to follow the IEP that the child came with?
I would say yes. Yes.
When you talk about the section, sorry, we were talking about that. When you talk about the section where the child's behavior is a manifestation, in other words, whatever they're on special ed for is a manifestation of whatever we've learned. And then you go into the further slide about it cannot be punished for more than 10 days if this was a result of their disability. How does that interplay in with criminal cases where you have a school board that calls a school resource officer to arrest the child, for instance, for battery on a teacher, and the teacher's aware that the child's frustration causes him to want to hit, and rather than letting the child be him, kind of standing back and trying to calm the child, and the teacher approaches the child, and then we have a battery house and he's arrested. Now, how does that interplay with this IDEA?
That's unfortunate because, like we've often said, part of the behavior intervention plan should not be the school resource officer, it should be the behavior person. But as a teacher, they have a private right to seek having the child arrested. There's no out for that because the student was a student with a disability. It's one of the things that I recommend that you educate the defense attorney about the child's disability, speak to the state attorney about the charges, and educate the judges. Because there's a whole thing about school to jail pipeline, and it's a serious problem where children are having their behaviors criminalized, and this follows them. Those points will follow them into adulthood. So it is a serious problem, and I wish there was an easy fix to that. But one of the things that we've often offered in the cases that we've been involved in is to educate the public defenders to testify on behalf of the child, you know, and to try to educate the court system, because too often children, for manifestations of their disability, they're known in their behavior intervention plan will do something, and unfortunately they'll get arrested and there is no like stop, wait. But one of the things that is important, IDEA says that individual education plan should be following that student into the juvenile justice system so they're aware. We had an unfortunate case where it was an elementary school child was arrested for a behavior clearly part of their disability, and we were frantic trying to get to the juvenile intake facility to make them aware that the child had a disability, because we didn't want that child having a nuclear meltdown in their facility and picking up more charges.